Recently, the Honorable High Court of Punjab and Haryana has delivered a landmark judgment and propounded the doctrine "let the court decide" syndrome, evolved in the administrative authority to evade their own responsibility. When any administrative action is taken against the government employee, it may be by way of punishment or for some other purposes. The government employee files an appeal or make a representation to the authorities, and when order is passed by the authorities, it is, in most of the cases, it is not a reasoned order, and sometimes there is an inordinate delay in deciding their appeals or representations, and thousands of cases are filed in the High Court, making a prayer that the order passed by the authorities is not a reasoned order or without any reason, or sometimes prayer is made to decide their representation or appeal which is pending before the authorities, and the precious and valuable time of the court is consumed because the administrative authority are ignorant of principal law. It is settled proposition of law that the reason is the life and blood of every order passed, and reason is the heartbeat of every judgment or order, either passed by the judicial authority or constitutional authority or administrative authorities. And the order without any reason is considered as a lifeless order, no order in the eye of law. So the Honorable High Court of Punjab and Haryana has taken a serious view in case titled as Suresh Kumar versus UHBPNL and some other connected cases, and decided this issue on 4th of March 2025. It is 140 pages judgment, and the important principle of administrative law has been discussed at length by the Honorable High Court of Punjab and Haryana, and the Honorable High Court of Punjab and Haryana has held that when administrative authorities by their act or omission evade their own responsibilities and leave it to the court to decide, it leads to a let the court decide syndrome, and which can be dismantled inter alia by taking preemptory measure like legal education, training, accountability. And the Honorable High Court of Punjab and Haryana has further said that the lack of knowledge of basic principle in the field of administrative law is also a strong factor causing aforesaid syndrome, means let the court decide syndrome. Therefore, the Honorable High Court of Punjab and Haryana emphasized the role of legal education, training in curbing the increasing tendency of administrative authorities to shift their responsibility to the judiciary, and Honorable High Court in the above said judgment directed the Union of India to ensure that in the training institute of civil servants, including the Labasana, Mansoori, educate and in-depth training and education to be imparted in the subject of administrative law by dedicated faculty on the subject. The Honorable High Court also directed that there may be some refreshers course for these officers who decide these representations or these appeals. And further, Honorable High Court has directed that the professor, legal practitioner, research scholars and other suitable resource persons to be associated in time with these persons. So the Honorable High Court has specifically directed that there must be some training to these officers, and secondly, the Honorable High Court has said that they are avoiding their responsibility. So this very important principle or doctrine, let the court decide syndrome, has been evolved or propounded by the Honorable High Court.